My Lady Chief Justice Mother Kome, please be seated. Since the days when I used to be at the university, earlier on, when I was a much younger man, I loved to speak without reference to notes. It gives you better clarity. But it allowed me at some point to make references to notes for two reasons. One, I'm before very esteemed judicial officers, judges, and magistrates. So I have to be careful what I say. Secondly, I'm representing His Excellency the President, and therefore I should also be careful what I say in that capacity. Outside that, I like exercising my mind freely, and my Lady Chief Justice and all protocols observed, I am proudly associated with the legal profession. I am not ashamed. I am proudly associated with the legal profession. And perhaps maybe when my 12 duty in this other space comes to an end, like all things do, maybe I will go back to where I started. I was impressed by what the president of the East African Magistrates and Judges Association said. Very many things about, actually, all the things he said. About the leadership of the Kenyan judiciary and the Regional Magistrates and Judges Association being female is a good thing for us in this part of the world. And the example that we see in Kenya, in this region, of affirming the leadership of women is a good thing. And I think we are providing leadership that should be emulated by other parts of the world. I know some countries like Rwanda have done better than Kenya, especially in political representation of women. Uganda, I think, also has done better than Kenya. But generally, as a region, we have good things to say about ourselves. And I am saying so because even in older, much older democracies, some of fasts that we have registered have not happened. They have not happened. The number of women in the judiciary, the legislature, in the executive at high level. I think Africa, East Africa, we are not doing badly. We are doing well. Of course, she said a few other things which I don't want to repeat. But I was impressed that our brothers and sisters from the region who are here are happy to be here, as it should be, because this is your home, just as your own country is also the home for your brothers and sisters from Kenya. So, because, Madam President, you said so many good things, the politician in me urges me to say that whatever you and this forum asks for, we will give you. I am delighted to join you here at the 2025 East African Magistrate and Judges Association Conference, a gathering that brings together the region's judicial minds and justice reform champions. This annual regional forum is a collective reaffirmation of our shared conviction that justice is the lifeblood of both national development and regional integration. This year's theme, Justice Beyond Brick and Mortar, Unlocking Multi-Door Pathways for people-centered justice in East Africa reflects a powerful and timely shift in thinking about justice reforms, that justice must evolve, expand, and adapt if it is to meet the needs of our citizens in an era defined by rapid economic change, demographic transformation, and the deepening of regional ties. Across East Africa, too many of our people still experience formal courts as distant, slow, costly, or intimidating spaces. Even the Chief Justice has admitted here that we are all intimidated. Even those of us who are lawyers and judges, the courtroom disorients us. How much so for the citizen who is pursuing some issue and they are from a corner there and this is their first experience before a judge or a magistrate. For millions, especially women, youth, small entrepreneurs, and rural communities, the justice system appears more like a fortress than a support structure. The consequences are profound. Disputes linger unresolved, economic opportunities are stifled, social tensions simmer, and public trust in state institutions weaken. When justice is inaccessible, development stalls, inequality widens, and the promise of the rule of law becomes hollow. Our judicial systems must therefore function not as barriers, but as open doorways through which fairness, dignity, and economic opportunity can flow to every corner of our region. It is in response to these realities that our judiciaries have increasingly embraced multi-door approaches to justice. Mechanisms such as the alternative justice systems, AJS, court-annexed mediation, small claims courts, and restorative justice processes reflect a growing recognition that justice cannot be confined to stone buildings or rigid procedures. It must instead travel to where the people live, work, trade, and build families. These pathways offer quicker, more affordable, and culturally informed avenues for resolving disputes, enabling justice systems to adapt to the lived experiences of our diverse populations. They reaffirm the basic truth, which is justice must not only be done, but must be felt by our citizens as accessible, humane, and relevant. The developmental imperative for scaling these multi-door pathways is clear. A functioning justice system is the operating system of any economy. When disputes resolution is slow and unpredictable, it weakens the legal foundations of commerce. It freezes capital and undermines property rights. The Kenyan experience illustrates the reality vividly. In the 2024-2025 financial year, 621,425 cases were filed, and our courts resolved an impressive 647,686, achieving a 104% case clearance rate. However, these achievements occurred against a backdrop of 490 pending matters at the end of the financial year, which, with just about 700 judges and magistrates serving a nation of more than 55 million people, the average case can take 3 to 5 years to conclude, far beyond the statutory timelines and public expectations. This pattern is not unique to Kenya. It is mirrored across the East African region, where rising population, increasing commercial activity, and limited judicial capacity combine to create structural. Behind these statistics, and livelihoods hang in the balance. A commercial dispute unresolved for years equates to capital frozen in litigation rather than circulating in the economy to create jobs and support innovation. A delayed land case denies a farmer credit, security, or inheritance stability. A prolonged family matter leaves women and children in agonizing uncertainty. In aggregate, this represents a silent tax on development, one disproportionately borne by the very groups our development agenda seeks to uplift. It is precisely, colleagues, this human cost that multi-door justice seeks to address by providing simpler, faster, and more accessible mechanisms that free up economic potential and restore confidence in the rule of law. Beyond our national borders, multi-door justice is central to the East African community's integration agenda. Investors and cross-border traders do not only assess market prospects, they evaluate their reliability, predictability, and timelines of judicial enforcement. A harmonized regional framework for mediation, small claims, and cross-border dispute resolution would create a seamless commercial environment across East Africa's 300 million consumers. Picture this: a situation where a manufacturer in Kigali contracts with a distributor in Nairobi with confidence, or a trader transporting perishable goods through Busia knows that any dispute can be resolved within weeks through enforceable regional mediation. This is the legal infrastructure necessary to support the free movement of goods, services, and labor, the backbone of our common market protocol. Yet the impact of multi-door justice goes beyond economics. At the societal level, these mechanisms strengthen the social contract by making the state visible, accessible, and humane. Alternative justice systems forums that integrate human rights safeguards in our communal and traditional systems of dispute resolution offer women excluded from inheritance pathways to reclaim their dignity and property. Community mediation provides young people with alternatives to violence or informal retaliation for grievances. Mobile courts and paralegal networks bring constitutional protection to remote rural communities, ensuring that justice is not a privilege of geography. These interventions are particularly essential as part of our peace-building initiative within this region. The transition toward people-centered justice also aligns with our global commitments, particularly Sustainable Development Goal number 16, which calls on us to build peaceful, inclusive societies anchored in effective, accountable, and accessible institutions. Without fair and timely dispute resolution, progress on the other SDGs, whether in health, education, gender, equality, or poverty reduction, remains fragile. It is for this reason that it is often recognized that justice is the bedrock upon which all the other social and economic gains rest. At the same time, as we expand these alternative pathways, we must also uphold safeguards to ensure that expediency never substitutes for fairness. Gender-sensitive guidelines, human rights protections, appellate pathways, and constitutional guardrails must form the backbone of all multi-door justice initiatives. For this transformative agenda to take root, we must move deliberately from innovation to institutionalization. Pilots, however successful, remain limited to reach unless they are embedded into law practice and judicial training, budgeting processes, and administrative culture. Our governments and judiciaries ought to establish dedicated funding streams to these initiatives as a demonstration of our determination to give these pathways a permanent home within the justice system. This will of our sovereign commitment to our people as East African nations that we are determined to strengthen justice as a public good. Kenya stands ready to work hand in hand with all judiciaries across the region to bring these commitments to life. Firmly believe that hard working together, harnessing and sharing our experiences, we can build judicial systems that listen to our citizens, represent their dignity, and deliver justice fairly and expeditiously. Ultimately, the future we envision for East Africa is not only about expanding markets, building highways, or deepening intergovernmental relations. It's about cultivating shared values anchored in fairness, dignity, and institutional integrity. Justice is the glue that binds societies and the foundation on which peaceful, prosperous, and united communities are built. By embracing multi-law justice, we transform our judiciaries from bottlenecks into accelerators of progress, from distant arbiters into community partners, and from symbols of exclusion into instruments of inclusion. This is the justice that traders need to advance commerce, that women need to secure equality, that youth need to imagine peaceful futures, and that our region needs to realize the aspirations of shared prosperity. This is the development dividend. It is within our reach, and it will be achieved if we turn the outcome of this year's conference into a decisive regional action. Demystify the justice system and make it accessible and acceptable to as many citizens of these pathways. We should not compromise on fairness and other fundamentals, including the quality of justice delivered even through those alternative processes. Thirdly, is that through judicial decision-making process and judicial dispute resolution processes, we must carry the national interests with us. And I think that's what Chief Justice Martha Koome was trying to illustrate. It is not enough to make a decision. That decision must help carry the sustainability of the nation alone. Because a decision can help or even undo in terms of preserving the continuity of the nation. And therefore, I think judges, magistrates, judicial officers occupy the driver's seats in providing the software that runs nations. You can build roads, connect people with electricity, build airports like we want to do, because we have realized we are doing well in many things, but we don't have a good airport. So in the next 2 months, we are starting to build a modern airport, because the one that exists there was built by our forefathers. Next time you come in Nairobi, you'll find something different. So, but you can do all that, but all that infrastructure, including the expressways, can be undermined by the fragility that comes with certain national interests being overstretched. So things like national security, things like national cohesion, and I dare say things like justice and fairness may not be infrastructure, but they are good software upon which the foundation of our respective nations is built. So as a judicial officer, you are expected, therefore, to contextualize your decision in the manner and style of incorporating national interest, so to speak. Because today is not my day, let me wish you well as you interpret your very, very, very central mandate in the survival of our countries. Please help us to sustain our nations. And I think the inherent quest for any people, for any society, is survival and sustainability. And from where I sit, many nations today are struggling with survival and sustainability. They are not sure that 50, 100, 200 years, the society will still be there and moving on. And that's where the struggle is. And that's where the anxiety, the insecurity is coming from. And lastly, even as we contextualize this national interest, we must also zero in to what is it at the individual level that provides either security or insecurity of the human being. Because, in my view, what we all aspire for is freedom from fear that someone or other interests, and freedom from want. I have challenged colleagues in the legal profession, including judges, that we've come a long way and we've made huge progress in asserting the place of human liberty. We've come a long way in asserting the place of women. If you compare where East Africa and Africa is today and 30 years ago, we have made good progress in terms of asserting the place of women, creating equality, and protecting vulnerable sections of our society. But only insofar as these groups and individuals are protected from harm, trying to provide security from them so that they don't fear for their lives and well-being. Where we have not done much is to assert the place of individuals, communities, to be free from want. And therefore, as you look at your Bill of Rights, just look at it again. As you look at the constitution of your country, you find we've concentrated a lot on the liberties that give the autonomy of the individual in terms of expressing themselves and associating and moving from one place to another. But I challenge you to consider that equally important, especially for Africa and the developing world, is the need to liberate the individual from the insecurities around poverty. And therefore, socio-economic empowerment should go hand in hand with civil, political, and democratic empowerment. And lastly, Africa, East Africa, and Kenya is no exception, still suffers from identity issues. And we are yet to canvass and aggregate our interests as individuals, communities, and nations to other equally important things than just identity. There's community, there's religion. And many of the African countries, and I'm not naming any, that are not doing so well as they should be doing is because of the pullback by issues around identity. I want to challenge you as thought leaders and the conveyors of justice to start helping us in your decisions, in your philosophy, in your lawmaking and interpretation process on how we can balance these very difficult issues around identity with equally more important priorities like interests. In other words, an average African citizen, what is more important? Is it the language they speak, the mother tongue they speak, or is it the life-sustaining prosperity issues that we should embrace to empower that person? In other words, many of our countries are struggling because of these issues around identity, ethnic, religious. And we've spent a lot of time trying to defeat those vices, and we should continue. But equally important, as judges, magistrates, thought leaders, help us to start conversing how we can create new identities, not around ethnicity and religion and language, but we can create new identities around interests. Ask yourself, what is the common problem of a citizen in Kenya, Rwanda, Burundi, Somalia? It is the survival of that person and economic interests. And therefore, you will discover, for example, a citizen in Tanzania has a greater interest in customers in Burundi who buy what they have than the immediate neighbor who has the same products that they produce. I'm just giving that hypothetically. But the point is, your neighbor and your best ally as you look for empowerment as an individual, as a citizen, is not the person who speaks your language next door, who produces the same bananas that you grow in your farm. It is the person who buys that banana in the next community, in the next country. And so this idea around creating a good market in this region, judges and magistrates should help us form new identities. We have lived for a long time worshipping the identities we inherited, and the borders, we can create new ones. And I think we are almost there, because I've heard here, we've sung the East African anthem, we've also sung, I've also seen the flag, the East African flag. And these are some of the things that create new communities. You may want to read a book as I end by Benedict Anderson. The book is called Imagined Societies. And the core argument in that book is that societies are abstract entities. They are imagined. Communities and societies are actually abstract. What we call our nations today have existed because of a number of things. The first symbol is the map. That map is what describes your country. From here, this coordinate to the other, and everybody inside that space feels they belong there. But it's just the coordinates, geography. The next symbol is the flag. You have one flag. You live in the same geographically defined area. You have one anthem. Without some of this, that identity will not be there. So the argument is, as we struggle with the East African integration issues and creating a new identity as East Africans and possibly as Africans through initiatives like the African Continental Free Trade Area and others. The things that the founders of our countries had foreseen, but we've been unable to unlock that potential. Judges and magistrates as thought leaders should help us create new identities. And even before we go to Africa as a whole, let us create a new identity for East African community. I like what Chief Justice Koome said, that looking at the audience, nobody will imagine that the people, the distinguished dignitaries standing or sitting in front of me, nobody will imagine that they come from different countries. They look alike, they are sitting alike, they are wearing alike, isn't it? So some of these things are imaginary, and therefore judges and magistrates, good luck, and do more of these things. This is an annual meeting. I don't know whether it should also take the form of a colloquium, so that you don't just have the national colloquia, you also have colloquia. We also have a regional colloquium where people can think through some of these things and try and create new identities and define new thinking that can be implemented by policymakers and define a new Africa, a new East African community. Thank you very much. God bless you with those